show, Science Dispatch Podcast. My name is Cameron English. I'm your host as always, joined by Dr. Chuck Dinnerstein, Director of Medicine at the American Council on Science and Health. And of course, our special guest, a return guest, our favorite legal scholar, Dr. Barbara Billauer is with us. Nice to see both of you. How are you?
Hot, but chugging along.
It's toasty out there. It's toasty for sure. It's like we got high hundreds here. Well, not high, but low hundreds in California.
I always said you were hotter than I am, Cameron.
Well, I'm blushing now.
Yeah, it's always hotter in coastal California for sure.
Yes,
and
indeed.
Central California is even worse. But we have a maritime breeze where I am, so I'm a happy person.
Well, thank you for rubbing that in our faces, Chuck. We appreciate that.
You're welcome.
Okay, well, we've got a fascinating story. This is Dr. Billauer's latest for ACSH. It's called "The Morning After Chevron, Courts Tell the FDA How to Do Its Job." So we got a spicy one here. Let me read this introduction, Barbara, and then you can take it away and tell us what's going on here. So you write, 2 cases now before the Supreme Court threaten to narrow or even eviscerate traditional judicial deference to agency expertise. Soon, we may see this deference afforded under the decades-old Chevron doctrine dismantled entirely, even regarding technical or scientific recommendations. FDA Commissioner Robert Califf, for one, isn't pleased. Okay, so before you get into the story, maybe you could explain what the Chevron doctrine is, because I know that that's a gas station. So start there, if you would.
Well, back in 1984, or probably started before then, the EPA had all their clean up the air regulations. And somebody came up with an idea that maybe they wouldn't be tacked with precise permitting accommodations, that they could lump together or cobble together a bunch of different permit requirements. And if they, as a group, came under the standard, they would pass, which enabled them, the industry, Chevron being in this case the one implicated, enabled the air polluting industry, in quotes, to slack off on one thing if they could make up the air pollution protection in another area. And they called it the bubble concept.
It's kind of like carbon credits today. You can pollute in one place
Exactly.
and buy some carbon credits in another to offset it.
Exactly. An offset. That's a very good word, John. Excellent. So this was in 1984 during the Reagan years, and Scalia was on the court at that point, and he thought this was a great idea. And so they came up with the Chevron doctrine, which said that if an agency is charged with implementing a particular statute, and if the statute is ambiguous, or if the construction of the statute is ambiguous, we will defer to what the agency says because, well, the agency should know better what was the intention, or the founding fathers intended on the agencies to take care of their own backyard or for whatever reason. And so thus was born the Chevron doctrine. There is a related doctrine called the Auer doctrine, which is very much akin to the Chevron doctrine, except that it pertains not to statutes, but to agency regulations, regulations that the agency makes in order to do its daily job. And there are 900 some odd agencies that are tasked with government, and they all interpret statutes or take care of their roles. And under Auer also, the courts say that the agency is allowed, if the agency gets deference in the event of ambiguity. Of course, under the Auer doctrine, these are agency regulations, so presumably the agency would have more direct involvement into what their own regulations means. In Chevron, it's giving the agency deference to interpret a legislative statute, not all across the board, only if it's ambiguous and only if the agency's interpretation is relatively reasonable. And in the Chevron case, it benefited industry. And not surprisingly, Scalia was tickled pink. And so that's the Chevron case. Over the past years, either mentioning Chevron directly or just going around it, the court says, no, we don't want the agencies to decide these decisions. And there are all sorts of quote-unquote legal reasons, the agency doesn't have the jurisdiction, they don't know if this is a legislative, blah, blah. So that's where we are today. There are two cases before the Supreme Court. They're both similar. They pertain to fishing vessels that are required by statute to have monitors on board to make sure that they're fishing in accordance with the law, meaning that they're not overfishing. The purpose of the law was to guarantee sustainability, fishing sustainability. The question is, who pays for these monitors? And on that, the statute doesn't say, which means it's ambiguous. And the agency has saddled the fishing industry with the cost. And of course, the fishing industry says, we don't want to pay for it, number one. Number two, they're taking up much needed space on our tiny fishing vessels, so we've got to carry these guys, and on top of that, you're making us pay for it. And so the question now before the court is, who gets to decide, meaning who gets to pay?
Well, just interrupt for a second, but there is precedent for the regulated industries to pay for their regulation, right? I mean, there's any number of places where there are user fees. So while this is an interpretation by an agency, it's not completely out of left field. It goes along at least with the precedent that other agencies have set or have been set by legislation in terms of how a regulation is to be paid for.
And so the question comes up is, why now is the fishing industry fighting back? Being that this is kind of like the practice of government, it goes on all the time. Why now?
Well, let me build on that and ask you another question. I get the impression from your story, and please correct me if I'm wrong, that you see this as sort of a threat to expertise in a sense, because what this effectively does is it allows judges to step in and maybe make a ruling where they don't have the insight to determine if a chemical's safe, or if a medicine should be, like you give the example of the abortion drugs, right? Should those be shipped across the country from one doctor to a patient? Like, these kind of questions are medical and scientific, and judges shouldn't be adjudicating those. Is that where you stand? Is that the threat you see from these decisions, possibly?
What I see happening depends on how the Supreme Court words its decision. So the legal community, the academic legal community, legal pundits are predicting out and out they're going to just trash Chevron and they're going to throw it in the toilet, which means that the court, that every ambiguous issue will come before the court, which will include technical scientific issues, including drug approvals, perhaps, or including who's giving permits to develop drugs, which in effect confers a monopoly in some cases. So the outcome will depend on how the Supreme Court words its decision, and the expectation by the majority of people in the legal community is that they're going to just trash Chevron entirely. I don't think they're going to do that. But then again, I've taken contrary opinions before, and thankfully I've been right. Came out on the Niffer-Prestone case. I said if they're going to decide it on standing, and that's just what they did. So I'm not afraid of taking contrary opinions. I don't think that's what's before them, to throw it out entirely and let the courts decide. I don't think they'll do that, precisely because a lot of these issues are issues that the judges don't want to touch with a 10-foot pole. So the question is, where will they cut the baby? And in the cases before the court, while the courts say that, with Chevron and agencies shouldn't decide, and even the Chevron case, this isn't about agency expertise. This is about bucks. Who's going to pay? And coming right down to it, are we going to make a decision on the side of industry, and the industry calls themselves the victims because on the other side is the government, and the courts are likely to bow down to the government, and it's not fair, and if the agency makes a decision, the agency is the government, and us poor fishing boat industry, Chevron industry, whatever, we're the victims. Well, it's a cute turnaround, but that's not the way many people see things. So the question is going to be, will the court be careful enough I think they will, to limit their decision to eviscerating Chevron only on matters that are either legal or political or economic, things for which you don't need any particular expertise, or things for which the judges actually themselves may have an expertise.
It seemed to me if you were making an economic argument about it, then actually the person paying the user fees is the consumer. At some point, all of those costs come back to us. Now, whether the agency does it and we pay for it through our taxes, or the industry pays for it and we split it between their marginal profit and the raised prices. I guess in some sense, if they ended user fees and did it simply through taxes, it would be much clearer where the monies for this were coming from, though it would be politically a much harder lift to impose the user fees on us, especially in industries that wanted to self-regulate.
And it's also more direct if the industry pays for it, meaning it's passed on to us. If it's transmitted to us via taxes, there's the winnowing effect and it takes down. What's interesting is there's, in one of the cases that describe the Auer case, and in looking through Scalia's discussions, his speeches on the topic, he comes right out and says, this is a political issue. In one of the cases, Kaiser versus Wilkie, Judge Kavanaugh said, oh, we don't want the agencies to decide because that's political. We want the courts to decide because it's not political. Exactly, that was, I can't just tell our viewers your response, but the guffaw was very noticeable. And get real, guys.
I was laughing, by the way.
Yeah. Get real, guys. This is a political issue. When in 1984, funny year, 1984, the Reagan-dominated court decided on behalf of industry, well, great, Chevron is wonderful. And now we have a Democratic president and democratically run agencies, which may change if we get a Republican president, in which case, who knows, they'll put Chevron back. This is so political. This is so political, and nobody's calling a spade a spade. This is really not a legal case. This is a political case.
Let me ask you, as we wrap up here, a final question. Some of the criticism I've seen I suppose the case that you're making here, Barbara, from other legal scholars, is that the problem with the Chevron doctrine is that it allows Congress to abdicate its responsibility of actually writing a statute that is very clear and says the agency may do this, it may not do this, this law does this, it doesn't do this. And then as a result of that, it gives these executive agencies an obscene amount of power. And we've seen examples of this that maybe we can discuss some other time, but you have instances where an agency just says, we are allowed to regulate this product based on our interpretation of this doctrine. And sometimes they get sued in court, and sometimes the court goes, we agree with them, right? And then that settles the matter. And so I could see this being a problem where these agencies become so powerful that they become the target of political influence themselves. So in other words, the argument works in the other direction too, is what I think they're saying. What are your thoughts on that?
I think the bottom line is it's all political. Whoever's in power will make a decision that benefits them at the moment. And the checks and balances is, if we don't like the way the agency is going, vote the other side in power in next election. That's the easy redress. You cannot, in writing any statute or any contract, foresee all possible outcomes. You can't. There are going to be ambiguities, especially in scientifically related matters, because we're on the verge of technology which is creating new products or new concepts or new ideas every day. So you can't. We have to accept the fact there will be ambiguity. When the ambiguity is clearly technical, the courts will not get involved, I don't think, because they don't want to. But then you have questions about even technical issues have economic implications. Who is the first manufacturer up at plate? Is the competitor coming up with a new drug or something like the other drug to avail themselves of this monopoly? And it becomes a financial issue at the end of the day anyway. And as long as we realize that much of this is about economics, or politics, whichever side of the aisle you vote on, then we'll have a clearer appreciation of what the courts are trying to do.
Very good. Well, our political system is political, is the takeaway, everybody. And people like money. I'm glad we could enlighten you all. Thank you for joining us, as always. You can follow us on social media. I'm at CamJ English. The organization is at ACSH.org. If you want to read Barbara's article, the rest of her writing, all of our writing, just go to ACSH.org. The whole library is up there. It's all free. And we're grateful for your ears and your eyes. Thank you very much, and we will see you next time.
Thank you.